Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this Honorable Court. Please be seated.
Good morning. This is day 2 of the July 2020 session of the Tennessee Court of Criminal Appeals in Nashville. To my right is Judge Bobby Holloway from Columbia. To my left is Judge Tim Easter from Franklin, and I'm Tommy Woodall from Dixon. All of you, I assume, have read or been told what is in the most recent Tennessee Supreme Court order about wearing masks in buildings. Also on the news last night, the Metro Nashville are going to start issuing citations for Class C misdemeanors if you don't wear a mask in public. I got up this morning and read Order 8, and to my delight, there is an exception to that rule for being inside any building that the state or federal government owns or leases. So we will continue with what we did yesterday. Y'all weren't here, I don't guess, but if you choose while you're arguing your case to remove your mask to argue, that is fine. We do ask that once your part of the argument's over, that you put your mask back on. You're welcome to leave it on if you want. And also, we are allowing counsel for both sides to sit at your table and argue. If you don't want to come up and be at the podium where other people may have been or not. I do ask you, and I've got it from a very reliable source, my wife, who watched some of the proceedings yesterday. She said it really does help if, when you're talking, if you kind of pull the stand of the microphone and speak as close to the microphone as you can. This is being aired on YouTube so that we comply with the constitutional requirement that court proceedings be open to the public. So if someone's watching us, we want them to be able to hear what you say. Is there anything else that I was? Oh, and I will add on the social distancing, letting you take your mask off while you argue complies with social distancing. The two of you are together, co-counsel for this appellant in the first case, and but it's still, whichever one of you argues, you can take your mask off if that's necessary. So with that, do we have any kind of preliminary matter this morning?
No, Your Honor.
Okay, would you call the first case, please?
State of Tennessee versus Lawrence Eugene Allen.
I did forget to remind that you've got 20 minutes to argue, 20 sides. There's not that. If you want to reserve some of that for your rebuttal, let me know and we'll save that.
Good morning, Your Honors. My name is Brandon Druten from Rutherford County Bar. Along with Charles Ward, we represent the appellant in this case, Mr. Lawrence Allen. I am going to leave my mask on. If for whatever reason you can't hear me, just let me know and I'll take it off. I'm happy to do that, but for right now, I'll leave it on. If it's all right with the court, I would like to reserve 5 minutes for rebuttal.
All right.
Again, as I stated, we're here for Mr. Lawrence Allen, the appellant in this matter. Mr. Allen was charged with 2 counts of aggravated rape and 1 count of domestic assault in Rutherford County. His trial in the matter started in June of 2018, after which he was convicted, ultimately sentenced. After he was sentenced, he filed a motion for a new trial. The hearing was had on that and was denied, and then he filed the appeal, which is why we're here today. Mr. Lawrence Allen was denied a fair trial in Rutherford County in this case for the reasons that I've put forth in our brief. I'm not going to rehash the entire brief. I'm certainly not going to insult your intelligence by doing that, but there are some key issues I wanted to talk about. All of the issues in the brief and all the issues that have been raised on appeal we feel are singularly sufficient to allow Mr. Allen to have a new trial, and also cumulatively as well. And we just want the court to be mindful of that request when making their finding in this case. The various reasons why Mr. Allen was denied a fair trial in Rutherford County. The first one is, I'll spend a little bit of time talking about it, was during the trial, state engaged in behavior that we believe was violation of their obligations under Brady versus Maryland. And in the AG's brief, in response to our brief, the issue was brought up that Mr. Allen is not able to receive relief on that issue because he didn't raise it with the trial court. That, frankly, is simply not true. In this case, there were pretrial motions that were filed, and a pretrial hearing was held on the case. I believe in this case in particular, Mr. Allen's case, the pretrial motions were filed December of 2017. The pretrial motion hearing was in January of 2018. One of those motions that was filed on behalf of Mr. Allen was, in fact, the Brady violation by the state in refusing to disqualify the exculpatory email evidence that was talked about there. So the fact that it was brought up in pretrial motions, it was ruled on by the trial court in the pretrial motion hearing, certainly is indicative of the fact that he did raise the issue with the trial court. It was denied by the trial court, but he still raised the issue, and so we would like the court to consider the issue here. The issue about Brady is ultimately, in the AG's brief raises the issue that Brady does not apply at the preliminary hearing stage. And that's not exactly accurate. The AG's brief responds and reports case law that says that there's federal authority and state authority that shows that Brady does not apply at the preliminary hearing stage. But again, that's not entirely accurate. In the AG's brief, they cite State versus Willoughby to say that the issue of our rules of criminal procedure, specifically Rule 16, specifically relating to discovery, does not apply in the General Sessions Court. While that is true, and that is what State versus Willoughby holds, that is a separate and distinct issue from a Brady violation by DAs. Brady violation is not necessarily related to just discovery. And so the finding in Willoughby that discovery does not apply at the General Sessions stage does not apply to Brady. The question about Brady, and there are multiple cases about Brady, and there's multiple opinions about Brady. When does Brady apply, and when does it apply in preliminary hearing? And if you do the research, I mean, you're going to find that there's opinions all over the board on that. And I think the reason behind that is there is a case, U.S. versus Davenport. I cited it in my brief. It's a Ninth Circuit case, and it specifically addresses the Brady issue. It's not a discovery issue. It's not a state criminal procedure issue. It specifically addresses Brady. And the language in that case holds disclosure to escape the Brady sanction must be made at a time when the disclosure would be of value to the accused. Doesn't give any indication as to when that is. And I think the reason why there's so many varying case opinions on this issue is because it's a case-by-case analysis that has to be determined. It's a fact situation. I don't think it's appropriate to apply a cookie-cutter mold to any case where there's a criminal prosecution and there may be a Brady violation, because for that particular case, you have to do a case-by-case analysis. Especially in this case, Mr. Allen's case, his charges happened in June of 2015. Also in June of 2015, Mrs. Allen ended up emailing the detective in charge and giving exculpatory evidence against Mr. Allen, who's the defendant. Those emails were not disclosed until December of 2017, 2.5 years after they were disclosed. In the meantime, preliminary hearing happened, at which point they still were not disclosed to the defendant. And then after the preliminary hearing, Ms. Allen ended up passing away. And so if you look at the language in Davenport, again, must be made at a time when the disclosure would be of value to the accused. I think the question has to be asked is when would be value to the accused? In Mr. Allen's case, because nobody could foresee that the witness would be unavailable at the time of trial, obviously, if the state had notice of the emails back at the time of the preliminary hearing, should have been disclosed to him at that point. And all of this is outlaid in the brief. But I think because of those issues, I think the court has to look at the Brady violation there and determine that Mr. Allen was entitled to those emails at the time of the preliminary hearing, not at the time 2.5 years later. That's the first reason that Mr. Allen was denied a fair trial. The second reason, and this is the bulk of the brief, or the majority of the brief, I should say, is the improper prosecutorial argument or prosecutorial misconduct that was conducted throughout the case. Most of the arguments in the brief refer to statements that were made during closing arguments, but the sheer volume of improper prosecutorial misconduct throughout the case is pervasive, persistent, and in often cases direct violation of the trial court's order. And this court has to be aware of all of the number of statements made by the prosecutors in this case that were improper. And I laid them out in the brief. The one I really want to highlight, during pretrial motions, defendant raised the issue of the prejudicial term of calling Miss Allen the victim, and couched it in ways to say that the term victim is a prejudicial term. Mr. Allen, just like every other criminal defendant that appears in a court of law, is presumed innocent until he's proven guilty. And by calling her victim, it presupposes his guilt. The trial court ruled on that pretrial motion. The trial court ruled before the hearing that victim would not be allowed. The term alleged victim could be used. Mrs. Allen could be used. Mrs. Kimberly Allen could be used. But the term victim itself was improper and could not be used. Made that ruling in writing, and then also during the trial, the issue came up during the trial, and the prosecutor kept calling Miss Allen victim. The issue was objected to. It was raised by defense counsel. It was brought to the judge's attention. The judge immediately said, "Yes, we've already ruled on this. We're not going to call Miss Allen victim anymore. Please don't do that," and it admonished both counsel not to do that anymore. And then immediately after that happened, the very next sentence out of the DA's mouth said victim again. And then the DAs proceeded to call Miss Allen victim 37 times during the case of the trial. 37 times. That action by the prosecutor, which is, again, in deliberate disregard of the court's order, deliberate willful behavior that's in violation of the court's order, because of the prejudicial term, that calling her the victim is prosecutorial misconduct or improper prosecutorial argument. And it's that, coupled with all the other statements that were made during the course of the trial, during the closing arguments, during just throughout the case. I mean, pervasive, persistent prosecutorial improper argument. And the court has to look at all of those as a whole. You can't just take an isolated incident and look at it here and look at it there. It has to look at it as a whole to determine whether or not the statements by the prosecutor were improper. And again, I've laid all those out in the brief. There were three statements in particular I wanted to bring to the court's attention regarding improper prosecutorial argument. During closing, there were three statements that stuck out. The first statement was that Mr. Allen beat her like a man, which, again, I think the choice of those words are used to totally inflame the passions of the jury. The other one, which happened right after that, was he beat the tar out of Miss Allen. And then the third statement was an allegation that Mr. Allen was victim bashing. Those three statements in particular, those choice of words by the DAs are deliberate and were persistent, and again, contributed to the whole mood of the trial. And I think the courts have to look at that to determine the impropriety of the prosecutor's statements and their attitudes during the trial. The next issue where Mr. Allen was denied a fair trial is regard to the admission of the photographs by one of the detectives. It was objected to at the time, both before trial and during trial, about these photographs coming in. They were improperly authenticated. Trial court held that they were able to be authenticated by some officer who wasn't there. Once those photographs came in, Mr. Allen had no choice but to testify, to describe the photographs, describe what happened in the photographs, and why they were taken. The photographs were admitted during the state's case in chief. They weren't admitted during the defendant's case in chief. But once they were admitted, he was put in a position where he had to testify to talk about the photographs. In the AG's brief, AG mentions that Mr. Allen is not entitled to relief because he could not cite to any authority that gives him relief for this, that where he was forced to testify against his own behalf. There's no possible way that he could cite to any authority because this situation is unique to him. Whatever other situation has occurred for other defendants and anybody else in this situation, that has no bearing on whether or not Mr. Allen felt he had to testify to explain these photographs. There's no way he can cite to any authority because it's personal to him. This was a personal decision to him. There's no authority out there for him to say, well, this is why I did this, because again, the situation was personal to him. And I want the court to understand in all of these cases, we have these rules and we try to make them hard and fast, but they have to be case specific and they have to be fact specific. And so while we have the guidelines, it's every case has to be judged on its own and circumstances of that case. And so the fact that he didn't cite to any authority means that he's not entitled to relief. Again, there's no way he can cite to any authority on that. And so I'll just submit that to the court. But Mr. Allen was put in a position where he had to testify to explain the photographs after they were improperly allowed in through the improper authentication. So that's another reason why Mr. Allen was denied a fair trial.
Before you use up your initial time, I'd like to ask a couple of questions.
Yes, Your
going
Honor.
back to the use of the preliminary hearing tape at trial. Did you object to the use of the preliminary hearing tape at trial?
The testimony, I believe so, yes.
The preliminary hearing tape and a transcript, as I understood, were offered by the state to show what Ms. Allen's testimony was.
Yes, and I believe in the pretrial motions that were filed prior to trial that was objected to and it was ruled on by the trial.
Okay. Did you, as one of the bases for objecting to the use of the preliminary hearing tape, did you argue that it was, in this case, not appropriate because the state withheld the recantation and that taints did you make any kind of argument
I believe,
based on that?
I believe that argument was made. I'm going to, full disclosure, I was not the trial counsel. So I personally did not make that argument, but I believe that argument was made. Yes, sir.
Okay. I saw in the briefs that, and I think you mentioned maybe, but that the emails that she sent recanting her testimony were admitted into evidence during the trial.
That's correct. Yes, Your Honor.
And were they admitted as impeachment proof or were they admitted as substantive evidence?
I don't think they were. I don't know. To be fair, I don't know. I don't think they were admitted.
Who introduced them?
The state introduced them.
Okay. And I don't think the defense would object to that being admitted evidence, would they? You didn't object to it, did you?
Or
did the trial counsel object to it?
I don't believe so, Your Honor.
Okay. Well, if they were admitted as substantive evidence, how can you be prejudiced that they didn't give you that evidence before the preliminary hearing? Because if you'd had it before the preliminary hearing and questioned the witness about them to try to impeach her testimony, she could have said, for whatever reason, I sent those emails and that's not the truth. What I'm testifying today is the truth. And she didn't, but you go to trial and the state is allowed to, when a witness is missing and a defendant has a fair opportunity to cross-examine, a tape or a transcript of that prior testimony can be introduced into evidence. So she is deceased by the time of trial.
Correct.
Her testimony comes in, and then if those emails are admitted as substantive evidence, that's much better than having her explain them away as just she was mad about something or she felt sorry for her husband and she sent those emails, but that wasn't the truth, what she's testifying now. She could have explained them away. So how are you prejudiced? How was your client prejudiced under those circumstances?
In the email, she indicated to the detective that there was another person who assaulted her on the evening that this happened. My client didn't find out about this until 2.5 years after the fact. He could have urged the police to do some more investigation. He could have found out on his own who this person was. He didn't know the existence of these emails until 2.5 years after he was charged. So the fact that he didn't know they existed, and the fact that she again indicates in the emails somebody else did assault me that night, he could have, he could have tried to find out who this person was, or again urged the police to continue their investigation, or something to that effect, Your Honor.
All right, you were starting to get into your rebuttal time, so if you want to save all of that.
I'll save it for rebuttal.
Okay.
Thank you.
Thank you.
If the court doesn't mind, I'll remain seated.
All right, pull the microphone up to you close enough, so. Thank you.
Thank you. Can you hear me?
I can.
May it please the court, Catherine Redding on behalf of the state. The defendant has waived his allegation of a Brady violation by failing to raise or litigate the issue in the trial court. The defendant did challenge the admission of the preliminary hearing testimony in the trial court, but he did not argue until appeal that the state had committed a Brady violation by failing to disclose the email prior to the preliminary hearing, or that the trial court violated his due process rights by admitting her preliminary hearing testimony at trial. As this court well knows, a party cannot raise an issue for the first time on appeal. An appellate review of such an issue is waived. Even if this court were to find that the defendant did in fact raise a Brady claim in the trial court, his contention is meritless because the Brady does not apply to preliminary hearings. In Willoughby, our Supreme Court stated that Rule 16, the discovery rule, does not apply in General Sessions Court, and based on Willoughby, this court held in State v. Chapman that the defendant in that case is not entitled to receive an eyewitness's exculpatory statement prior to the preliminary hearing or the convening of the grand jury, which is similar to what happened in this case. Further, federal courts have stated that Brady itself was never intended to apply to pretrial proceedings and that Brady doesn't apply to preliminary hearings. Even if this court were to find that the defendant did preserve this claim and that Brady applies to preliminary hearings, he is not entitled to relief because he can't show the email was material, meaning in this particular case that there is a reasonable probability that the result of the preliminary hearing would have been different had the email been disclosed. Purpose of a preliminary hearing is to determine whether there's probable cause to believe that crime has occurred and that the accused committed that crime. Here, the evidence before the General Sessions Court included Ms. Allen's testimony that the defendant put his hand inside her vagina, hit her in the head multiple times, and caused her to develop a black eye, bruising, swelling, and pain in her jaw. Her testimony was more than enough to establish probable cause. And although the email could have undermined her testimony and disputed the state's proof, the probable cause standard that applies in preliminary hearings allows for conflicts in the evidence. Because there's no reasonable probability that the outcome of the preliminary hearing would have been different had the email been disclosed prior to that hearing, the defendant is not entitled to relief under Brady. And I'll just note for the court that the email was admitted, the state admitted the email at trial, and put it in through the detective who actually received the email. So that came in.
Did the state put it in, or the trial court rule that it was only impeachment evidence, or was everything silent about that where it obviously came in as substantive evidence?
I believe it came in as substantive evidence. I don't recall a clarifying instruction for the jury on how they were to consider it. I talked about the admission in my brief, and according to my brief, it just says that it just looks like it came in as substantive evidence through the detective who actually received the email, and a copy of the email. I believe it was read to the jury, and the jury received a copy of the email to review during deliberations.
Okay.
Was there any evidence that the prosecutor, the state's attorney, knew that these emails existed at the preliminary hearing?
No, I believe that the prosecutor said that she didn't discover the emails until after the preliminary hearing. I'm not sure. I don't know how they came. I don't recall how they came up, but I believe that the record is clear. The prosecutors did not know about the email, even though the detective did. It just wasn't turned over. And
This detective did not turn them over.
Correct. But once the state found it, realized that this existed, it turned it over before trial and then admitted it as part of its case in chief. So the jury was able to consider this email that was exculpatory. As to the defendant's next claim, the trial court acted within its discretion when it admitted these photographs of Miss Allen into evidence. First, the record supports the trial court's determination that the state did authenticate the photographs, which depicted Miss Allen nude and laying on the bathroom floor. The defendant told Detective Fate during his police interview that he had used Miss Allen's phone to photograph her as she lay on the floor covered in blood. This statement was presented to the jury at trial. Miss Allen testified that at the preliminary hearing, which was admitted at trial, that the defendant used her phone to photograph her during the offense. Miss Allen's aunt, who came to the residence the morning after the offense to take care of Miss Allen, testified at trial that the bathroom, when she got there, the bathroom was covered in feces and that she was present when Miss Allen looked at her phone and found photographs on that phone depicting what had happened on the morning of the offense. Miss Allen's aunt didn't actually see the photographs, but she was there when Miss Allen discovered them and refused to show them to her. Detective Neighbors testified that the law enforcement found photographs on Miss Allen's iPad after her death, and that the properties for those photos showed they were taken on an iPhone on the morning of the offense around 4:30. Second, the defendant's claim that he was forced to relinquish his privilege against self-incrimination by the photographs admission is meritless. As an initial matter, the defendant waived this issue on appeal by failing to cite any authority supporting his argument. Further, defendant feeling pressured to explain why he took the photographs is not the same as being forced to relinquish his privilege against self-incrimination. This court actually rejected a similar claim in State v. Givens, which I discussed in my brief. And this court explained that because the evidence at issue in that case was admissible, accepting the defendant's argument would transform the opportunity afforded every criminal defendant to respond to the state's proof into a violation of the privilege against self-incrimination. As to the defendant's third claim, he is not entitled to relief due to improper prosecutorial argument. First, the defendant's not entitled to relief based on the state's use of the term the victim because he can't show that it was improper to use that term.
The trial court ordered it not to be used, didn't he?
So the trial court...
Yes or no? Did the trial court order victim not to be used, that word?
On this... The initial order was, you have no case law to support your point, but it's okay to refer to a victim of a crime as the alleged victim, so I think we should just go ahead and do that. And then the defendant did object during trial when the state referred to Ms. Allen as the victim and directed the parties, please call her the alleged victim. And there were multiple references to Ms. Allen as the victim. But it's the state's position that the defendant can't show that the case law in this court is that the state calling the person they've identified as the victim of a crime, the victim at trial and during voir dire, that's not error. There's been 3 cases, and I cited them in my brief, where this has come up, but it's not
the important
really discussed.
issue, at least to me, is not whether the trial judge was right or wrong in telling the state not to call Ms. Allen the victim. The important thing to me is the trial court ordered the state, don't use that term. Now, am I misunderstanding what happened?
No, I think the initial order directive was a little unclear, but the court did clarify to the state, do not call her the victim, call her the alleged
Do you
victim.
dispute defense counsel's statement that the state attorney, in spite of the trial court's order, used that term 37 times in the record? You didn't address that in your brief, I don't think. Do you dispute that?
No, the state did refer to her multiple times as a victim. I think the issue, although the state did refer to her multiple times as the victim, I think that the defendant is not entitled to relief because he can't show that calling her the victim prejudiced the outcome of the trial.
Well, at some point under the rule, there's also a requirement that it either show prejudice to the defendant or to the judicial system. And I would like for you to focus your argument on whether or not a prosecutor disobeying a trial court 37 times during a trial is prejudicial to the judicial system.
I think that parties have a duty to, obviously have a duty to obey the orders of a trial court. I think that what makes this particular circumstance a bit unusual is that the trial court acknowledged there's no case law saying that you're not allowed to do this. Obviously, the court ruled, please don't call her the victim, call her the alleged victim. But it's common for prosecutors to refer to the person that they've identified as the victim as the victim. The state didn't use the term the victim solely to, the state only used the term the victim to identify Ms. Allen. I think possibly because the defendant and the victim had the same last name. And there's no proof showing that, yes, the state did repeatedly call her the victim, but there's no proof showing that the state did that because it was trying to usurp the jury's role in telling the jury how to decide that, yes, she is the victim rather than.
How would you prove that? How, I mean, again, the thing that I'm concerned with is if 37 times the prosecutor did what the trial court had ordered the prosecutor not to do. The defendant objected to it.
Yes.
The prosecutor kept doing it.
Yes.
That's what's concerning me, not whether there's law that says the state has to do that, not whether there's law that the trial court was in error ordering the state to do that.
Mm-hmm.
That's not the concern as far as I'm concerned.
Well, I'd point out for the court that the defendant did object, but then didn't request a mistrial, didn't take any further steps. I realized that the objection, there's only so many times you can object to a repeated reference to Ms. Allen as the victim. The defendant did not take a step to try to have a mistrial declared on this issue. And I think that the reason you can say the jury didn't just take this wholesale, take the state's argument that Ms. Allen was in fact a victim of the crime wholesale and just reach its determination based on the use of that term, is because the jury made a considered decision and considered the evidence rather than the arguments of the prosecutor or defense counsel and declined to find him guilty of one of the counts of aggravated rape. So I think that you have defendant didn't make a motion for a mistrial, and you have a jury by its verdict showing that it was not just swallowing the arguments of the different parties and that it was looking at the evidence and really studying what was there and reached its decision based on the evidence rather than the arguments of the parties.
Okay.
And second, the state's position is that the defendant is not entitled to relief based on any improper prosecutorial argument during closing arguments. The defendant waived these claims by failing to contemporaneously object to any of the alleged improprieties during closing arguments that he's talked about in his brief. He's not requested plain error review, nor has he addressed any of the plain error factors. He declined to file a reply brief addressing these issues under the appropriate standard of review and hasn't talked about them today. And it's the state's position that even if he were to entertain a plain error analysis, he would not be entitled to relief. Unless the court has any questions about the particulars.
I have a question about your Brady argument.
Yes.
I understand that the outcome of the preliminary hearing might have been the same had the emails been provided to the defendant. What concerns me is that the testimony of the victim might have been substantially different had the defendant known about those emails before she testified at the preliminary hearing. And in this case, the victim was killed in an unrelated homicide before the trial. And so now the state and the defendant are left with the testimony from the preliminary hearing to put in for an unavailable witness. Do any of the cases that you found, the Chapman case, I think you cited from our court and some federal cases, involve preliminary hearing testimony where a Brady violation or Brady issue occurred, and then the victim was not available due to death or some other reason?
I don't believe so. I don't believe Chapman knows the most on point, and in that it was dealing with an exculpatory statement prior to preliminary hearing, but I don't recall whether that witness was unavailable at the time of trial.
Do you know if the record explains why it took 2.5 years for the state to disclose these emails to the defendant?
I don't know why it took that long. Defense counsel may recall. I know that there was an issue. Detective Fate was no longer with the police force, so I don't know if that played into it. But my recollection on why it took so long is not clear. But it is clear that the state did disclose it before trial and did put it in as part of its proof, and that obviously because the Miss Allen was no longer living, she was not there to explain why she sent this email or what the circumstances were.
Does the record show when Miss Allen died, at least in relationship to a preliminary hearing?
I think it was within a week of the preliminary hearing. It was very close in time after. So, if there are no further questions, the state asks that you affirm the judgment of the Rutherford County Circuit Court. Thank you.
I'm not sure how much time I have for rebuttal. The timer's not working, but
We don't use the timer usually.
okay.
I'll keep
apologies.
up. You've got your whole 5 minutes.
Okay.
so.
I shouldn't take the whole 5 minutes, but I'll address. Regarding the issue again about how my client was prejudiced by the emails not coming at the preliminary hearing, before you asked your question, I had written down that certainly if she had testified live at the preliminary hearing about the emails, it could have changed the posture of the whole case. Certainly, whatever answer she gave, whatever her demeanor was regarding these emails, I mean, certainly it could have influenced the DA to not pursue the charges or not pursue the trial or offer a lesser charge or something to that effect. Again, we'll never know because she wasn't able to testify at the preliminary hearing. Regarding your question about whether or not there's any cases about an unavailable witness, I don't believe there are either. Not that I could find anyway in my research. There may be some out there, but I didn't find any that spoke to that point. But I think Judge Easter asked the question about the state's, the emails belong to the detective and why the state's attorney didn't have it. I do think that's correct. I don't think the DA, frankly, the record is unclear whether or not the DA had the evidence at the time of preliminary hearing or not. But it is the state's witness. I think the DA has an obligation to ask their witnesses for all the information. And again, that was the only witness at the preliminary hearing was the Detective Fate and the victim. But
to be clear, I could not agree with you more about that.
So if that information is in the hands of the state's witness, I don't think the state gets to sandbag the case by saying for 2 years we didn't know that this email didn't exist because nobody told us. Well, it's the state's witness. So I don't think they're exonerated by saying we didn't know it didn't exist, especially for 2.5 years. And then the question that you asked about the court's order, why the DA chose to violate the court's order 37 times in regard to this victim statement. I agree with the order did say there's no case law to back this up, but it still was an order. It still was an order of the trial court. We're still going to follow this order. And if we choose to operate under the assumption of we have pretrial motions, these pretrial motions have been ruled on by the court, but then we're going to come back later and disavow them or not acknowledge them, then I don't even know why we have pretrial motions to begin with. What's the purpose of doing that if we can just disobey the court's order and do what we want to. So Your Honor is correct. The question is not whether or not the trial court was right in ordering it or not. He did order it. The trial judge did order it. And then the state proceeded to continue to violate that order. So that's the reason why we're asking for this case. All the reasons I've already talked about and the reasons in the brief, we're asking this court to remand the case for a new trial back to Rutherford County for Mr. Allen.
Did you have a chance to review and see whether or not that email came in as substantive evidence or impeachment evidence by the state, or was it silent?
Again, I think it may have been substantive, but I don't want to.
Okay.
I don't want to swear to that, Your Honor.
Okay. All right.
Thank you.
Good briefs written for both sides in this case, and the court wants to thank each of you for using the terminology of improper prosecutorial argument. For some time now, the judges of the appellate court have been trying to quit using that term prosecutorial misconduct, because it's not our place to determine whether a lawyer commits misconduct, and we didn't want to leave an impression and that we were saying some kind of ethical violation. But I appreciate y'all using that terminology. That's all we have until 10:45. All right, we'll be in recess till 10:45. Thank you very much.